I will present some questions about judicial reaction and response to rule of law, backsliding, and examples of judicial resistance in Romania. In less than 2 years, 2017, 2019, several amendments were made to the key laws governing the justice system in Romania. The laws initially were adopted in 2004 as part of the accession requirements undertaken by Romania to improve the independence of the judicial system. But among these new harmful legislative amendments, a new procedure for the interim appointment of the management of the judicial inspection and the establishment of a new section for the investigation of the judiciary offenses as a part of the prosecutor office, whose investigation allows to transfer dozens of files of high-level corruption from the dockets of the National Anti-Corruption Directorate, holding thus the investigation, and the changes in provisions regarding the material liability of judges, elimination of merit-based judicial qualification standard for appointments to the higher court, and especially to the High Court of Cassation and Justice in Romania. These amendments were criticized by Venice Commission, by the relevant Professional Association of Romanian Judges and Prosecutors, and after that by the Consultative Council of European Judges, the Consultative Council of European Prosecutors, and the European Parliament, and also the European Commission in several CVM reports. This is the historical context in which the judges and the prosecutors in Romania staged unprecedented protests, largely supported by by universities, professors and students, as well by the civil society and actors of the national theater, for example, not in a formal collaboration of different groups regarding the judicial resistance, but in a form of spontaneous solidarity with judges and prosecutors. So how Romanian judges and prosecutors fought for the European values? Protest judges and prosecutors have the right to stand against any other policies or action affecting their independence. For example, in December 2017, and after that in February and March 2018, in September 2018, in February and March 2019, thousands of Romanian judges, prosecutors, and judicial trainees from the National Institute of Magistracy silently protest in front of their institution, holding their robes or the Constitution, but most of them showing printed versions of common oath they took when sworn into office at the beginning of their career. And this silent protest concerned the changes of the criminal codes and the changes of the laws of the judiciary. And in April, 4 April 2019, for the first time in history, judges from a member state other than Belgium protested in Brussels for the rule of law. It was a protest, a large protest at the Brussels Palace of Justice, Rond-Point Piétonnier, la Place Polaire, in front of the Court of Cassation in Belgium, attended by around 13 Romanian judges and prosecutors, who were applauded by dozens of colleagues from Belgium and Germany, judges from Belgium and Germany, and also Belgian lawyers. This was the first form, and the other form, continuous dialogue with of the Association of Judges and Prosecutors in Romania with the relevant European and international entities, European Commission, European Parliament, Venice Commission, Consultative Council of European Judges and Prosecutors. Not tomorrow, but next Wednesday, we will meet again the European Commission in a visit in Romania regarding the new report of the CVM regarding the Romanian justice. Well, representative of Romanian Judges Forum Association, for example, met Mr. Timmermans in 2019 in actions that concern the state of justice in Romania, in Brussels, and also Vera Jourova. All the official of the European Commission has assumed its role of defending the rule of law under the Article 2 of the European Union, and the dialogue with the Romanian judges and prosecutors, I think, is essential for the technical appreciation of the whole context, with judges being technically experts only within the limit of their status. And similarly to the situation of the deterioration of the rule of law and the judicial system reform in Poland, in relation to which the Court of Justice of the European Union has already delivered several solutions or principles, or has other application for a preliminary ruling pending, the Romanian courts have also referred to the Court of Justice on the interpretation of the European Union law in the context of legislative amendments of or a constitutional court decision. It was my idea to send preliminary ruling of the Court of Justice of the European Union. It was in 2018, and the first one was in January 2019 regarding the ad interim position of the judicial inspection chief inspector. The Court of Justice joined the first 5 requests for the preliminary questions, although they were addressed as separate requests from courts situated in various regions of Romania, Pitești, Craiova, Old Tribunal, and other. The inexplicable reaction of some presidents of Superior Council of Magistracy and the contradictory decision of the Constitutional Court of Romania, which refused to take into account the opinion of Venice Commission, arguing that it exercised its control exclusively by reference to the national constitutional norm, have determined the domestic judiciary to refer preliminary question of the Court of Justice of the European Union to try to remedy the lack of the legislative response to the persistent regress from the rule of law. And we have probably more than 20 requests for preliminary rulings registered with the court. The court pronounced in several cases. The first 6 cases was the first solution was in May, 18 May 2021. The inspiration came from the first relevant judgment of the Court of Justice, Associação Sindical dos Juízes Portugueses, on judicial independence being reviewed under the Article 19 of the treaty. The first request for preliminary ruling raised to the issue of what is an independent disciplinary procedure for Romanian judges without risk of political influence over the conduct of those proceedings. In concreto, it inquired about the conformity of the governmental appointment of the chief inspector of the judicial inspection on provisional basis following an emergency and governmental order with the CVM decision, the report issued by the European Commission within the framework of this decision and the Article 2 and 19 TEU. The chief inspector in this first case tried to block the procedure, filing a request for relocation of the first request for the preliminary ruling to another tribunal. This action led to further requests for preliminary ruling being sent by several other courts because all the judges in Romania were stimulated to cooperate in this kind with the Court of Justice of the European Union. So 4 other requests for preliminary ruling concerned the interpretation of the Article 2 and 19 as regard the establishment and the functioning of this special section for investigation of offenses committed within the judiciary. The president of the Romanian Superior Council of Magistracy also initiated a relocation and cancellation of one of these requests for a preliminary ruling concerning the newly established but not yet functioning in this time section for the investigation of crimes in justice. But this was rejected, but only 1 year after the date of addressing the request for the preliminary ruling. So the Superior Council of Magistracy and the Judicial Inspectorate, the Judicial Inspection, tried to block the procedure in all these cases, first 6 cases sent by the Romanian judges at the request of the Romanian Judges Forum Judges Association in the first case. But after that, it was the judgment of the court of the judge of the Grand Chamber of the Court of Justice of the European Union delivered in the first 6 cases on May 18, 2021 has caused a real earthquake in Romania, and it was extremely intense, so intense that in order to maintain the previous state of affairs, the Constitutional Court of Romania immediately intervened by this decision 319 on 2021, 8th of June, contrary to the Court of Justice judgment, ordering that national ordinary judges may not analyze the conformity of the national provision, which has already been found to be constitutional by decision of the Constitutional Court in relation to the provision of European Union law. This decision of the Constitutional Court of Romania are binding under the Article 147, paragraph 4 of the Romanian Constitution, and also we have provisions, the Article 99, letter sh of the law regarding on the status of judges and prosecutors, allow the initiation of disciplinary action by the judicial inspection and disciplinary sanction for judges for non-compliance with the decision of Constitutional Court. And the chief inspector, who was the same chief inspector who was notified after the cascade disciplinary action brought against the former president of the High Court of Cassation and Justice, the former chief prosecutor of the National Anti-Corruption Directorate, and the judges and prosecutors who protested publicly against the amendments contrary to the rule of law, brought to the status of judges or prosecutors in Romania, began in 2021 the disciplinary proceedings against judges who proposed and those who referred to the Court of Justice of the European Union in the cases mentioned above, causing the immediate reaction of the European academic community and also the European Commission. And also went the first and the only judge who has applied in Romania the Court of Justice judgment of May 18, 2021, being accused of committing the violation of Article 99, letter T of the law on status of judges and prosecutors, which refers to acting in bad faith. In fact, the latter had established the priority of applying the European Union law, revoking the prohibition of the law, National Law 304 on 2004 on the judicial organization of the Special Prosecution Office that exclusively investigates judges or prosecutors. His case is pending now, and hearings will be in April, 13th of April, I think, at the Superior Council of Magistracy, the disciplinary section for judges. So these forced actions raised concern by the European Commission, which sent a letter to the Romanian Ministry of Justice, and probably the initiation of an infringement action for non-fulfillment of the obligation of an EU member state by Romania is imminent. After that, it was this judgment of the Court of Justice of 21 December 2021, Eurobox promotion and others. The judgment established that the national judges are entitled to disregard the decision of the Romanian Constitutional Court that are not aligned with the EU law without any risk of disciplinary measures. Moreover, it addressed Romanian justice reform and pointed out the mandatory character of the EU recommendation embedded in the European cooperation and verification mechanism. After that, it was this ruling of June 29, 2021. The Craiova Court of Appeal referred to the Court of Justice of the European Union, the case RS 430 on to 21, and the Court of Justice pronounced this judgment on February 22, 2022. But under pressure for the Constitutional Court's decision, ordinary judges in Romania refused to apply the judgment of the European Court of Justice. And the example is provided by the High Court of Cassation and Justice in special, because the High Court of Cassation and Justice refused to apply using this decision of the Constitutional Court 390 on 2021. They held, for example, in one of these judgment pronounced in September 2021, that the issues identified and analyzed by the judgment of the Court of Justice of European Union are not binding on the ordinary courts, since other state bodies are empowered to cooperate with the political institution of the European Union in order to achieve the benchmarks set out in the annex to decision, the CVM decision, and the lack of substantive jurisdiction of the prosecuting body cannot be established by reference to the existence in the active substance of legislation of rules which precisely lay down the jurisdiction of the prosecuting body. And we have more than 20 judgments of the High Court of Cassation and Justice, the administrative and fiscal section, and also the criminal section in this way. And the play also includes the Superior Council of Magistracy, because in this period, 2017-2018, the Romanian Parliament adopted these laws affecting the judiciary, and these amendments eliminated merit-based judicial qualification standard for appointment to the High Court of Cassation. And the last contest, with the interviews conducted in January 2022, seems to be in line with the view of the Constitutional Court of Romania, trying to select only candidates which accept the interpretation of the internal body, the Constitutional Court of Romania, and reject the interpretation of the European Court of Justice. And the President of the Superior Council of Magistracy use questions addressed to the candidates absolutely in this way. And the president of the Constitutional Court in Romania, also Mr. Valer Dorneanu, in a recent speech, he explained that it was very clear that the national laws means treaties, regulation, decision, no CVM reports, not opinion, not recommendation. Two of this ruling of the CGU made it clear that they are indicative and they provide lines of action, said Mr. Valer Dorneanu. The duty of this sincere cooperation may impose a positive obligation on member states, not only in the sense to prevent themselves from infringing EU law, but also in preventing other persons from foiling the provision of the treaty by their action. Furthermore, the duty of sincere cooperation will also be breached if a member state does not sanction who infringe EU law in the same way as it penalized those who infringe national law, namely in an effective, proportionate, and dissuasive manner. But who should react? Because the European Commission, the guardian of the treaty, seems to be just a spectator of play in this moment. A new case, 817 on 21, the Judicial Inspectorate, was Register of the Court of Justice of the European Union. In this case, the Court of Appeal, the Bucharest Court of Appeal, the 8th Division for Administrative and Fiscal Disputes, referred to the Court of Justice of the European Union for a preliminary ruling on this, on the following question. The Article 2 and 19, second subparagraph of the Treaty of the European Union, and the decision, CVM decision, establishing this mechanism for cooperation and verification of progress in Romania to address specific benchmark in the areas of judicial reform and the fight against corruption, must be interpreted as opposing a national regulation allowing the chief inspector on the judicial inspection to issue normative, infralegal, or individual administrative acts by which to decide the organization of the judicial inspectorate for the selection of the judicial inspector and the evaluation of their activity, the performance of the inspection works, or to decide on the appointment of the deputy chief inspector, if according to the organic law, these persons are the only one who can carry out, confirm, or reject acts of disciplinary investigation against the chief inspector. By these amendments, 2017-2019, the Judicial Inspectorate has become in Romania practically a sort of pyramid-type public authority, with its unique in Romanian judicial system for the benefit of a single person, with an extended discretion, including in adopting the organizational regulatory framework, confirmation or reversal of judicial inspector decisions. In this structure, judges and prosecutors appointing judicial inspector by the chief inspector are completely subordinated to this inspector, with the risk that their functional independence is substantially affected. And the last one is a new, very recently on 10 March 2022, the Court of Appeal from Alba Iulia, Administrative and Fiscal Litigation Section, ordered the referral to the Court of Justice of the European Union of a new preliminary ruling. In fact, this court, the Romanian court's request tends to ascertain mainly whether, if in the interpretation of the Court of Justice of the European Union, the principle of judicial independence framed in Article 19, with reference Article 2 and 47 Charter, and the principle of sincere cooperation laid down in Article 40 EU preclude the national provisions such as the Article 148 of the Romanian Constitution as interpreted by the Romanian Constitutional Court by the decision 319 on 21, according to which national courts cannot take account of the provision of the European Commission decision regarding CVM and the recommendation made in the CVM reports for implementing of the benchmark on the ground that the national courts are not empowered to cooperate with the political institution of European Union. And this is the case 205 on 22 CDA. The last case of Romanian judges sent to the European Court of Justice. But in this, in the joint cases, the first 6 joint cases, the Court of Justice of the European Union held that Romania must take due account of the requirements and recommendation made in the reports drawn by the Commission pursuant to this decision. In particular, that member state, Romania, may not adopt or maintain in the areas covered by the benchmark measures which would risk jeopardizing the result they foresee. The discussion remains ongoing since sincere cooperation is not limited to simply operation of reporting on progress, for example. It rather includes the obligation to take recommendation into account when adopting legislative or administrative measures in the areas covered by the CVM benchmark, as Bobek, the Advocate General of Bobek said says in the opinion in the case C83 on 19. Which also states that since the CVM reports do not contain any legal obligation, they cannot in themselves be relied on either before the EU court or before the national, the internal courts. In such circumstances, the involvement of the Court of Justice of the European Union seems to be the only serious option. Thank you.
Thanks indeed,